pronouns. So this is going to be our first pro se session for the folks that were arrested on the highway on November 4th. Our hope for tonight is that we can give you a brief overview of what the process of representing yourself might be like, and some advice from some of our movement lawyers. So tonight we're going to have Josh Esme from the Legal Rights Center and Bruce Nestor from the NLG with us. And maybe we can go ahead and do a quick round of introductions, just the folks that are panelists on the call. We have a few folks here doing tech support and chat support. So again, my name is Maddie. I am the organizer with the NLG, and I use she, her pronouns, and I will pass that over to Treya.
Hey everyone, I'm Treya. I also use she, her pronouns. I'm mostly here to be Zoom support. I'm here with MUAS, and I'll pass to Jason.
I'm not hearing that.
Okay.
I'll go while Jason figures that out. I'm Garrett. I use he, him pronouns, and I'm helping out with fielding questions from the chat for this meeting. So hopefully you won't hear too much from me. I use he, him pronouns.
I'll jump in. Am I showing up? What am I doing wrong?
No, you're good, Bruce. Go ahead.
Okay, I'm just not showing up on video, but that's fine. My name's Bruce. I use he, him pronouns. I'm an attorney with the National Lawyers Guild and a private practice attorney in town, and appreciate the opportunity to support you all in the struggle and the opportunity to provide you legal advice as you navigate the court system.
And hi, everyone. I'm Josh Esme. I'm an attorney at the Legal Rights Center. Also, he, him pronouns. And similar to Bruce, I'm happy to be involved and be helpful any way I can.
Awesome. Thanks, everyone. So again, we're hoping to provide an overview of what this process will look like if you're going into the court system without an attorney. We know that you all probably have a lot of questions. This is largely an unprecedented situation for most of us. It's the largest mass arrest that we've ever seen in Minnesota. So with this many people facing charges, we're going to have mass defense strategies that look different and more creative than we typically would. And that's gonna probably look like a mix of people who have volunteer attorneys, private attorneys that they're paying for themselves, and then folks that are gonna be representing themselves pro se. So this is meant to be kind of an introduction into what that could look like. So we'll start with Josh and Bruce presenting on that process. And then at the end, we'll have a question and answer piece. So if you have questions that you're thinking of throughout the presentation, hold on to them until the end to see if they get answered. And then once we're done with the presentation, you can start typing your questions into the Q&A function. It should be either up here at the top of your screen, or it might be down at the bottom for you all. But try to type them into the Q&A section, not into the chat box, because it's a little easier to track. So with that, I will go ahead and pass it over to Josh and Bruce.
All right, thanks, Maddie. I'll get us started. I'm going to sort of walk through kind of the timeline or the process of kind of the start of the case to the finish of the case. There's a couple different hearings that are required by rule before you get to the trial. So we'll talk about what those hearings are and what to expect at those hearings. And then I'll hand it off to Bruce, who's going to talk a little bit more about meeting with the prosecutor and the process called plea bargaining, which is negotiating for a resolution and sort of what dispositions might be on the table from the perspective of the state. And then we'll take everyone's questions. So the first thing that happens, or the first hearing, is often called an arraignment or a first appearance. It is a kind of a much less formal hearing than what you're going to see once you get to the trial. And the kind of the primary purpose of it really is to get you there in court, to make sure that you know about the charges, that you're coming to court. If people don't show up at the first appearance, then the prosecutor will ask the judge for a warrant, which would authorize law enforcement to arrest that person and bring them to court for that first appearance to get the case going. Other than showing up, there's not a lot that is expected or required of you at that hearing. There is some opportunity to do some work at the hearing, and a couple things can happen. One of those, and I know that we're all here for a pro se meeting, and so maybe everyone who's sort of in this audience has already thought through this and decided it's not a good fit, but one of the sort of main things that happens at that first appearance is it's the opportunity for the person who's charged with the crime to apply for a public defender. So if that's something that, you know, that you're at all thinking about, then that would be your opportunity to do that at that first appearance. Basically, it, you know, involves telling the court that you want a public defender, asking questions about your income so that the court can make a decision about whether you qualify. And then if you do, you'd meet with the public defender that day and kind of go from there. There's also the possibility to start negotiating and even resolve the case at that first appearance. Typically, the Minneapolis City Attorney's Office is going to have a file there with your case that has the charges, and one of the attorneys has sort of already looked at it and typically made an offer to resolve the case that is going to be available at that first appearance. So you can meet with an attorney, or oftentimes a student attorney working under supervision of an attorney from the city, who can communicate that offer and explain what it is. There may be some wiggle room to negotiate. Oftentimes, though, in my experience at that first appearance, it's kind of like the attorney who's there for the city is really just sort of there to move the case along. And they may or not even be the attorney who came up with that offer, and they may or may not be the attorney who is ultimately going to be responsible for doing the work on the case. So oftentimes they're not going to really be in a position to want to negotiate all that much. So you might not be able to get very far negotiating, but you could at least start that conversation and inquire about it at that first appearance. And then the only other thing that really happens at the first appearance is that you schedule the next hearing in the process, which is called a pretrial hearing. You can, when you meet with the city attorney, you can also ask about discovery, which is what we're going to talk about next. So discovery is basically the process and the rule that entitles you to have access to all the information about your case that the prosecutor has. So at a very basic level, you're going to get everything that's in the prosecutor's file. You just have to ask for it. And there's, you know, the rules in terms of how you do that are pretty flexible. Like I said, you could simply ask for it at that first appearance. And they may talk to you right then and there about the process for getting it. I think we are also going to try to make available to this group form motions that you can fill out to demand discovery and formally file into the case. You probably don't actually need to formally file the motion into the case to actually get the discovery. Usually just simply telling the prosecutor you want it is gonna get you there, but it can be a good idea to file it into the case anyway, because you make a record then that you've asked for it, and in the event that there ends up being anything that you need to fight over in terms of the discovery, you're definitely going to want to have it filed. In terms of what you might fight over from discovery, so usually the way the process works is a court clerk, or not a court clerk, a law clerk or a paralegal at the city attorney's office is basically processing these discovery demands for, you know, the thousands of cases that the city prosecutes per year. And so they'll start basically by just, you know, making a copy of the prosecutor's file, everything that's in there, the complaints, the police reports, body camera video, any audio recordings. Sometimes there's audio recordings of interviews that happen with an investigator and a suspect following the arrest. All of that stuff, if it's in the prosecutor's file, they're going to get to you with, you know, typically with no hassle. If there's something that seems obvious that they don't have, usually just sort of a follow-up request is going to get it. Sometimes though, there's stuff that you think should be in the discovery that's not there. This is sort of we run into this sometimes with body camera videos, or, you know, it can vary from case to case, but something that, you know, because you were there, that should be there, that isn't there. And in that situation, you know, you can follow up, ask the specific prosecutor for it. They'll usually tell you, hey, I'll look into that. Then they'll go and ask the cops about, you know, whatever piece of evidence or information you're after, and usually get back to you with either, yeah, we have it, or no, we don't have it. If it's something that they think that you're not entitled to, then you could end up having an argument that the judge would decide, and ultimately either order the city to produce that piece of information or not. All of that stuff for now, I think, you know, just have on your radar as, you know, as a possibility. But most often you're going to get most of the information you'd expect to get, just with a simple discovery request. The sort of timing of that discovery request, I don't think you need to wait for the first appearance to ask for it. Sometimes if you ask for it before the first appearance, they might not get it to you, just because their workflow often has that happening, you know, between the first appearance and the pretrial. But you might get it, you know, right away just by asking for it, and I think that that's fine. Although there's no rush to ask for it before the first appearance. Kind of the typical timing of it is that discovery demand happens between the first appearance and the pretrial conference. And so that brings us actually to the next hearing. We can go to the next slide.
Josh, can I just jump in a second here?
Yes, please.
So I think this is just an example of where a hybrid model where some people have attorneys, but not everyone does, can still work for everyone's benefit, where there are, you know, a group of over 600 defendants. So I think everyone, for instance, should request their own discovery the way Josh just talked about. But if you don't have an attorney, you probably don't need to get too concerned about discovery disputes. People with attorneys might create some of those discovery disputes. For example, we may say, we want all the planning documents involving law enforcement about how they were going to pull this operation off, and show that they were going to shut down the freeway no matter what, or just because we want it and we want to see that the governor approved it or the head of state patrol. Those battles can all be fought by attorneys in cases where people have attorneys, but can then rebound to everyone's benefit, you know, depending what happens or not. That's all I have to add.
Yeah, I agree with that. Okay, so the pretrial conference then, oh, actually, one more note about the first appearance. The first appearance is going to happen actually at the public safety facility, which is the jail, or sometimes called the new jail. But that's the only hearing that's going to happen at that public safety facility. The pretrial conference and the trial then are going to happen across the street at the government center. All of the misdemeanor pretrials are all in the same courtroom on the 11th floor. And so the pretrial conference is kind of, in terms of its level of formality, it's pretty similar to the first appearance. It's also pretty informal. It involves, again, sitting down and meeting with the prosecutor who's got the file. Now at the pretrial conference, you're going to get the individual prosecutor who's probably going to be responsible for actually handling the trial if the case doesn't resolve before then. I say probably just because I'm kind of coming at this from the perspective of how it normally works, and it is possible that the city handles things a little bit differently, just given the volume of cases related to this protest event. But you're going to get a little bit more ability to actually negotiate. The prosecutor who's going to be there at the pretrial conference has the actual authority to make decisions about the case that the prosecutor that was there at the first appearance may not have had. So really kind of the primary thing that happens at the pretrial conference is this meeting with you and the prosecutor that goes, hey, we resolve this case, and negotiating whether or not that can happen. If it doesn't happen, then you set the trial date. If it does happen, it can resolve at the pretrial conference. The other main thing, other than, do we need a trial or not, that gets answered at the pretrial conference is if there's going to be any other pretrial litigation, any other issues that the judge needs to decide before we get to that trial date. And so that could be, suppression issues, if there's an opportunity to make an argument that, that your constitutional rights were violated and that the prosecutor shouldn't be able to use the evidence that they have against you because of that. Those are types of things, issues that you would want to raise at the pretrial conference. Again, those are things, kind of Bruce's point about, the sort of the hybrid model coming to the, being able to be leveraged to benefit everybody, including pro se litigants. I think that that point stands for this part of it too, where there might be like a motion to dismiss for lack of probable cause or something like that that is being made in other similarly situated cases that we might be able to leverage in your case too. So in terms of what those motions would look like, really what we need to do on that is take the discovery, review the discovery, do some brainstorming about what arguments we may be able to make. I think that is going to be sort of the primary conversation for ongoing workshops. And one of the things we'll talk about here as we get to next steps is scheduling the next one. But in terms of sort of the overview of the process, the pretrial conference is where we're going to want to have those issues identified and let the court know that we're going to litigate them and schedule those. And then after the pretrial conference, could come another pretrial hearing to litigate those issues, pretrial issues like suppression or motions to dismiss. But then after we get past that, we get to the trial date. And we can go to the next slide. And so the trial date, this is where, the process of deciding, the court deciding whether or not you're guilty or not happens. And the main thing from the trial that I would want to stress is that, it's your name on the case, but it's really the state that's on trial. And the reason I say that is whether it's a petty misdemeanor charge or a misdemeanor charge, it's the state who has the burden to prove their case against you. And if they can't do that, even if, a jury or a judge may think, hey, I think a crime probably did happen here, but there's a defect or a mistake in the state's case and they can't prove it, then, then an acquittal should be the outcome that you get. So I guess one thing to touch on here is the difference between a misdemeanor and a petty misdemeanor in terms of the trial. So a misdemeanor is a crime, and it's the lowest level crime, but it is a criminal offense. What makes it a crime by law is the possibility of jail time as a punishment for that. Petty misdemeanors are not crimes, and the reason they're not crimes is because jail is not on the table. It is not a potential punishment for a petty misdemeanor. The only potential consequence for a petty misdemeanor is a fine. And because of that distinction, your rights are a little bit different with respect to a trial. You still have the right to a trial for both types of cases, and you still have the right to have the state carry, have the burden for both types of cases. I just thought a quick question here about what about a felony? Felonies are crimes too, just like misdemeanors. Basically, the same set of rights applies to misdemeanors and felonies with respects to trials. For the most part, you get with misdemeanors, you have a smaller jury, only 6 people. Felonies have a larger jury, but with both misdemeanors and felonies, you have the right to a jury trial. So what the trial process then looks like, whether or not it's to a jury or if it's a petty misdemeanor, it's just going to be a judge that hears the evidence and makes the decision about whether the state has proven their case or not. Either way, though, the sort of the fundamental process of the trial is pretty similar. It starts with the state presenting evidence first. And again, that's because the state has the burden to prove their case. They'll present evidence by calling witnesses. I imagine in almost all of these cases, the only witnesses that the state is going to call are going to be law enforcement witnesses, so cops, who will take the stand and tell the jury what they observed. You will have an opportunity to question, or what's called cross-examine, the witnesses after the state is done with them. So that's an opportunity to try to get them to add facts to the record that might be helpful to you that they otherwise would have glossed over because they weren't helpful to them. Or it could be an opportunity to get them to admit that there are things that they didn't know, things that they didn't see, or limitations to what they could have seen, those types of things. And you basically do that by asking them, yes or no questions, or simple short questions. How far away were you from the street when you observed, the yelling that you claim to have observed, or whatever it is. After the state has presented all of their witnesses, then the opportunity then comes for the defense to present their case. And so the defense can present witnesses. They're not required to present witnesses, but they can present witnesses. And that's going to be something that, on an individual case-by-case basis, we'll probably be looking at whether that makes sense or not. And again, something that we can help you with at further workshops to decide whether or not you should call witnesses and what they should testify about. You also have the right at the trial to choose whether or not you want to take the stand. And the law allows you to do that. And in some cases, it's a really good idea to do that. That gives you your opportunity to tell your side of the story. And for the fact finder, whether it's the jury or the judge, to hear directly from you and assess your credibility. But it doesn't always make sense. And there's lots of situations where it doesn't make sense to take the stand. And again, part of that comes back to the state's burden, right? You might not want to take the stand and subject yourself to cross-examination and be a position where you have to say something that hurts your case. If you decide not to take the stand, the judge will instruct the jury that they can't hold that against you, which means that they can't sort of engage in the kind of quote unquote common sense line of reasoning of going, well, if I was innocent, I would want to take the stand and tell everyone I'm innocent. This person didn't do that, therefore this person must be guilty. The judge will instruct the jury not to think that way. And obviously, if it's a petty misdemeanor trial, the judge will, take that into consideration too. After both sides have presented their witnesses, then there's an opportunity for closing arguments, which is sort of your last opportunity to summarize the case, talk about the evidence that was presented at trial, and ask the jury to decide in your favor based on that evidence. That's about it for a quick summary of the trial. Bruce, is there anything you want to add there?
I think just 2 points about potential trials in these cases. One is whether everyone's going to get tried individually or potentially in groups. Right now, you are charged individually, and the presumption in Minnesota, meaning what happens in the typical case, is that individuals would be tried individually even if they committed a crime together. But either side could move for something called joinder. And what that also means that all your charges will be tried together that you have. You're not going to have 2 separate trials, one on your public nuisance and one on your petty misdemeanor in this type of case. But you can have joinder of defendants also. And the state may say, we want to join people together in groups of 15 or 20, if only for efficiency purposes, to try to get through this number of cases. We conceivably could say, hey, we want to try groups of people too, because we want to present this as a collective activity, as First Amendment activity, as social justice, protests. And that's much more obvious when it's a collective defense and there's 20 people or 15 people than when you all go in by yourself. Or we might oppose joinder and trying people in groups, because we want there to be 646 trials as part of our pressure on the system. or because you can argue that being tried with other people might prejudice you or harm you, and that you might have a defense that they don't have. So those decisions, again, don't need to be made right now. They don't need to be made by you individually right now. It can be part of a collective process of discussion where, again, I think you can get input from an attorney. One last benefit of a collective trial would be if you have 15 people, you might have 2 people represented by an attorney and others who aren't. And this kind of gets to my second point, which was Josh talked about the right to remain silent. Well, normally, if you testify at a trial as a defendant, you get up there on the witness stand, you take an oath, you answer questions from your attorney, but then you got to answer any questions that the prosecutor wants to ask you also. If you represent yourself pro se, you get to give a closing argument and an opening argument. And as any lawyer will tell you, opening and closing argument aren't evidence. It's your view of what the evidence might be, or your view of what the evidence shows. And so it really gives you as a defendant, when you're not represented by an attorney, an opportunity to speak directly to the jury. And you really get to push the bounds of what's allowed, I think, in closing and opening argument, because attorneys, for the prosecutor's not going to want to interrupt you repeatedly or argue that you're saying things you're not supposed to be saying, because they're going to appear kind of like this technical nitwit while you're a real human being, just, telling the jury what your side of the story. No one can predict exactly how that goes, but that's potentially a very valuable benefit to being pro se, and a valuable benefit to being trying cases in a group, because then you get a benefit of an attorney to make objections and know all the legal rules, but you still get the benefit of pro se people who get to speak directly to the jury, much more from the heart, much more in a human style than the way a trial might go. So I'm going to back up to my main topic then, which is the plea bargaining. The initial point about plea bargaining is that the system absolutely could not survive without it. In the federal system, I think about 95% of cases are resolved by plea bargains. I'm not sure what the percentages are in the state system in Minnesota or across the country, but they're very, very high also. And the criminal justice system just has to be a meat grinder. It has to process large volumes of people, because so much more money is put into enforcement, i.e. cops, than put into prosecutors, public defenders, certainly judges and courtrooms. I mean, if you really wanted to give everybody a trial, you'd have to have, quadruple the number of judges, public defenders, prosecutors, etc., and spend far more resources on it. So the benefit of a plea bargain is that you often get some certainty. You know what the punishment's going to be, and you normally get it's something far below what the crime would normally call for. I remember my very first criminal case back in 1993. I was representing a guy on driving under suspension, and I was super detailed and very fastidious. We ended up negotiating an agreement. We walked into court. We pled guilty. I was going to convince he was going to get 90 days in jail because that was the maximum penalty for the offense. And then you find out, no, the whole point of plea bargaining is he paid a fine and got no jail time, and paid a fine way below the maximum fine. The point is that, again, so the benefit from the defendant side is that you resolve a case early, you know what it's going to be, and you get penalties that are far below what sound like might otherwise happen. The maximum penalty for a petty misdemeanor is a fine of $300. As Josh said, you can't get any jail time for it. You can't really get any penalty for it other than a fine of $300 or less. It's not a criminal charge under Minnesota law, meaning it's considered to be a violation, more like a parking ticket than a criminal violation. On the other hand, that may or may not be meaningful to an employer or a landlord in the future who sees that you have public nuisance on your record as a petty misdemeanor. They may still just treat it as a crime, whether it's a petty misdemeanor or not, or whether under state law it's really a crime or not. A misdemeanor, on the other hand, has a maximum punishment of 90 days in jail, a maximum fine of $1,000, or both. You generally aren't going to get 90 days in jail on a misdemeanor. On most misdemeanors, you're not going to get any time in jail. Even on a more serious one, like a DWI or domestic assault, most people are going to do some type of community service, unless there's some aggravating factors or something like that. And I say that so just that you think if you do end up going to trial on a misdemeanor, it's not like and everyone's going to tell you, you understand you could get 90 days in jail. It doesn't mean that it's very likely that you're going to get jail time, even if you were to lose at trial. So the point of plea bargaining then is to have a discussion with the prosecutor about how to resolve your case. People have lots of different considerations in that. One may be that you want to keep something off your record entirely. Another may be that you just don't have time to go to court and you want to resolve this quickly rather than have 5 or 6 more court appearances. Or you may be concerned financially about the amount of the fine that you might get, or not want to do community service if ordered to do that instead of jail time. Or various considerations about the penalty that you get and about having something on your record. In these types of cases, I think a third concern might be whether an agreement, a plea bargain, does anything to restrict your ability to engage in future or additional protest after you enter into that agreement. And so there's a number of ways to potentially keep something off your record. There's something called, I don't think you need to remember all the details of these now, but to know that there's a variety of ways to keep something off your record, if that's a key for you. One is something called a continuance for dismissal, where you don't plead guilty, the case is normally continued for 1 year, and you agree to do certain things during that 1 year. Normally that would be to pay a little bit of money, do some community service, and then obey the law. And you can haggle about what obey the law means, whether it means a new conviction, a new charge, or it might only mean an offense that is the same or similar to the current offense that you're getting the continuance for. The downside of that type of agreement might be that it does restrict your ability to do stuff for the next year, because if you got arrested again, then they can bring that old charge back. So what a continuance for dismissal means is if you do everything you're supposed to, then after a year, it gets dismissed. And it's truly dismissed. It's not on your record. You have no conviction. If you don't do everything that you're supposed to, then the case can be called back to court. And generally, you would have the same right to go to trial on it that you had before you resolved it by a continuance for dismissal. There are other ways in which you do formally plead guilty, but the court may not pronounce you guilty, or even if they pronounce you guilty, everyone agrees that after 1 year that the conviction could be vacated and taken off your record if you do certain things. Those certain things, again, are typically pay some money, do some community service, and stay out of trouble. Whether those will be offered or available in this case, that is up to the city attorney. The judge really has no power to offer a continuance for dismissal or another way to keep it off your record. That's all up to the prosecutor and the city attorney whether they wish to offer that. So that's kind of one major consideration. How do I keep something off my record if that's important to me? The second would be kind of bargaining between a petty misdemeanor and a misdemeanor. Typically, the city is going to out of the gate offer a petty misdemeanor in these types of cases for people who don't have any prior offense. And they do that because they want to resolve as many cases as possible at the outset, so they don't put resources into producing discovery, getting cases ready for trial, and ultimately trying those cases. A petty misdemeanor can have a fine up to $300. Often it would be less. The benefit of a petty misdemeanor is that you don't have any conditions on your behavior. You just pay the money and you're done. And then you have a violation on your record. You don't have something hanging over your head. You don't have a misdemeanor on your record, and you don't have any conditions that you have to follow, such as stay out of trouble for a year. Most of you are charged with a petty misdemeanor. It's also possible for a misdemeanor public nuisance to be converted into a petty misdemeanor. That could happen either because the prosecutor calls it a petty misdemeanor or designates it, would be the formal language, in which case the court would have to have your consent to lower it to a petty misdemeanor. And the reason is that lowering it to a petty misdemeanor, as Josh said, takes away your right to a jury trial. But again, that may be that you want a public nuisance isn't something you care about having on your record because it sounds so vague, but you don't want it to be a crime. And so you could plea bargain to reduce it to a petty misdemeanor, meaning that the city either calls it one with your agreement, or you just agree on a penalty where the penalty is going to be $300 or less. Because even if a misdemeanor, if it's punished as a petty misdemeanor or less, then it's going to be treated as a petty misdemeanor by the system in the future. Then if you end up, if the city won't offer you a petty misdemeanor, won't agree to sentence something as a petty misdemeanor, you're then talking about what type of sentences do you get on a misdemeanor if you want to plead guilty to something. Again, that's not going to involve jail time. Typically, that would involve community service or sentence to service, like a community work crew, instead of or in lieu of jail time, in that you pay some type of money. But then that's going to be a misdemeanor on your record. I would think that unless you have a prior record or unless you have a significant other protest-related arrest in recent years, there's a very high chance the city will offer petty misdemeanors on many of these charges. Or they'll try to certify them as petty misdemeanors to take away your jury trial right. One of the forms that we're going to be putting out in the future that people can use on their own would just be to make clear their objection to that if they wish to preserve their right to a jury trial. In terms of the process of plea bargaining, sometimes people think that, the closer you get to trial, the better offer you get. And so defendants turn down every offer until the eve of trial. Prosecutors know that too, and sometimes they say, this is the best offer you're going to get right now, and if you keep making me work and do work on your case, then that offer's off the table, and the day of trial, you're going to plead guilty to a misdemeanor or nothing. The petty misdemeanors offer's off the table. I don't think that's going to be true in this type of case, given the number of cases and given the past behavior of the Minneapolis city attorney. What that means is if you go into that arraignment, your first court appearance that Josh talked about, and that attorney that doesn't really know anything about your case makes an offer and you say, no, thank you, I want a new court date, that offer isn't going to go away. And if it is going to go away, they're going to tell you when and why or how it's going to go away. But generally, I would think the city is going to be eager to resolve these cases, even on the eve of trial, so that you can really engage in plea bargaining and your position might change. You may be dead set on going to trial right now and making the city pay the price for deciding to arrest so many people. But 6 months from now, things have changed in your life and you want to try to resolve the case. Of course, you always can try for a dismissal as part of a plea bargain too. Again, the judge the judge can dismiss the case under certain circumstances. I won't get into that now. The prosecutor will dismiss it if they don't think they have the evidence to prove you guilty. That's not so much plea bargaining, but it's not something to take off the table. I don't think we have to agree that everyone automatically, their option is go to trial or take a deal. We could certainly push for dismissals also. I think as we get into these cases into February, March, as trial dates start to get set, attorneys who have clients will get the same basic offers you're getting and will be in a position to evaluate whether they make sense, whether they're too punitive, whether the facts support the potential of a conviction at trial, and will be able to give at least general advice that would be to your benefit as to whether a particular plea bargain in your case is reasonable or in line with what other people are getting. And so you're not going to have to make all those decisions just on your own without any yardstick or guidance on how to assess the type of offer that you're getting. Josh, anything to add to that?
I don't think so.
I guess that'll wrap up on plea bargaining then.
So I think the plan from here is to open it up to questions.
Awesome. Thank you, Bruce and Josh, so much. So folks, I see that there's some questions in the Q&A right now, but if you have any questions left still, go ahead and start typing those in there. Bruce and Josh, I can just start reading the questions out to you guys, and whoever feels like answering can just go ahead and jump in if that works.
Sure.
Perfect.
Alrighty, awesome. The first question is it that you either will or will not qualify for a public defender, or is there some sort of sliding fee option for a public defender?
I can answer that one. So there's no sliding fee. It is binary, either you get a public defender or not. That being said, there is a little bit of wiggle room around the margins for it. Sort of kind of typically the way the process works is you fill out the application, and it's kind of a bright line rule based on your income, whether you're going to qualify or not. If you are close to that though, and the court tells you, you don't qualify, but you're right near the cutoff line, you can ask the judge to sort of reconsider that, and even have an opportunity to go up in front of the judge and explain why your income situation is such that you just can't afford to hire a private attorney. And sometimes judges will sort of extend that bubble a little bit and appoint a public defender.
Thank you, Josh. There's a question about whether first appearances will actually be happening at the jail or if they'll be virtual because of COVID.
Yeah, I totally glossed over that. So we are currently under an order from the Supreme Court that no out of custody hearings. So if you're not in jail right now and you're required to go to court, you're out of custody. The current order is that there are not to have any of those hearings until at least February 1st. So the answer to whether it's going to be virtual or in person really is going to depend on whether that hearing ends up being scheduled before February 1st or not. And I suppose it's possible too that gets extended depending on kind of what the situation looks like in terms of the pandemic.
So just to clarify that, there are hearings from now to February 1st, but all the out of custody hearings will be by Zoom video.
Right.
Okay, that makes sense. Thank you. Okay. Is it possible to share evidence with others, with other charged individuals and compare evidence? As in, is it legal to share and is it strategically advantageous?
So I'll respond to that. The discovery is provided to you with a general limitation that it's to be used in your case only. What that means is you're not supposed to turn it over, just hand it over to a newspaper reporter or use it for other purposes. That's probably more important in a more significant case. I don't know that anyone's going to bother to get upset about it in this type of case. But yes, generally, you're not allowed just to share it willy-nilly. You certainly can share it with other charged individuals because that's part of the process of comparing evidence, discussing common defenses, and common strategy. And so I would think, the answer is yes, you can share it with, as long as it's for the purpose of defending yourself in the case. And if you're just going to do it to make publicity points or go public, you probably should talk with someone about whether that's a wise thing to do under your particular circumstances.
Oh, go ahead.
So can I just take the next one here, Maddie?
Mm-hmm.
So the question is, I'm wondering how we can even make a case against a public nuisance charge for pedestrian on the highway, since we all had to be on the highway to get arrested, and there's no way we weren't on a highway. Good question. Couple of, I think some of this needs to be thought out and talked about, but there are certainly defenses available. One could be that you did not intentionally end up on the highway. You were part of a large group of people engaging in peaceful First Amendment activity. All of a sudden, you found yourself in the middle of that crowd walking down kind of a steep ramp. And before you knew it, you were on the interstate. You couldn't really turn around, walk back up it, and boom, the police blocked you in and you couldn't go anywhere. So you did not intentionally or voluntarily go on the interstate. You ended up there and were trapped there. A second potential defense is that the element of public nuisance involves blocking the highway. And there is a Court of Appeals decision from the I-94 cases around Philando Castile's murder that the prosecutor has to prove that you blocked the highway, not that the police blocked the highway or not that other people blocked the highway. And so a potential defense is, yeah, 645 people went and blocked the highway and I joined them 10 minutes later, but I didn't do anything to block the highway because it was already blocked. And that's where Josh's point about who bears the burden of proof is important. You're not the one having to prove that you showed up 10 minutes after the other 645 people. The state is the one that has to prove that you intentionally and voluntarily went on the highway and blocked the highway through your own individual actions, not just through your collective action with other people. Now, I'm not trying to guarantee you that all those defenses work in this case. I'm just telling you they're out there. They need to be developed, thought about, strategized, and figured out how you would present them to a jury of 6 people in a way that would lead them to make a decision that you're not guilty of a crime.
Yeah, and I would just also add, especially, and this is one of the reasons why we tend to value jury trials so much, is, the other thing that happens is ultimately whether to convict or not is a decision that that those 6 people make, and they're given instructions that say, yes or no. Did you find that this fact, which is an element of the case, was charged or not? And it could be like, were they on the highway? Yes. Did they block the highway? Yes or no, et cetera, et cetera. But there's this legal concept called jury nullification, which, basically boils down to the jury could look at all it and say yes to all those questions and still say, I'm not convicting this person. And if they do that, there's no real recourse for the state. And jury nullification is something that, like, it's sort of a difficult thing to build a trial strategy around, because there's pretty significant limitations on what you can ask the jury to do with respect to it. But it's just sort of another fundamental kind of protection there that if the jury thinks that that you shouldn't be convicted of a crime and they quit, they quit.
And I'll chime in. That's an example of having a pro se person being able to do opening or closing is really valuable, because then you get to talk about how you were trapped there by the police and how you were all, the evidence will show that we were trapped by the police. The evidence will show we would have gone up an exit ramp and left. The evidence will show the police blocked it for 5 hours, not us. But you don't have to testify and get cross-examined necessarily by that in the same way. And that's part of jury nullification, is just getting the jury to think this person didn't do something worth being punished for.
Exactly.
Awesome, thanks. So I know there's a lot of questions in here and we've got about 7 minutes left. We will save these questions and we can work on answering them so that we have answers ready for the next session. And the next Pro Se workshop will be in mid-January. So there will be more time, and the next one we'll be able to go into a little bit more detail about all the different steps. But I see one here that I think should be easy to answer. Some of us have citations that say we committed the offense at 35E in Maryland Ave. So we have court dates in Ramsey County in February. I assume we should ask for discovery as our first step. So I can jump in real quick and say every Ramsey County, every citation number that I've checked that said Ramsey has actually been dismissed. Some of those have been recharged in Hennepin County. So you would just want to run your citation number, and maybe Garrett could drop the link to do that in the chat if people aren't familiar. But you can check your citation number online to see what the status of your case is. So if you had Ramsey County on your citation, check to see if it's been dismissed. But Bruce or Joss, maybe you could address the second part of that question, if they should ask for discovery at their court date in Ramsey.
I had a Ramsey County case representing an individual. I asked for discovery just because I wanted to make them work. but they dismissed right away. So I don't think it makes a difference. I think the Ramsey County, St. Paul City Attorney knows these cases were mischarged and has spoken to the Minneapolis City Attorney about it. At least in my case, the city attorney for St. Paul said that the Minneapolis City Attorney said the case would not be recharged. It was just dismissed in Ramsey. If you were mistakenly charged in Ramsey, though, keep that in mind as we head towards a trial date, because that's certainly a cop not knowing whether you were at 35 in Maryland or in Minneapolis or Ramsey or Hennepin certainly goes to their ability to accurately describe events of that day.
Absolutely. Thanks, Bruce. And then there's a couple questions on this topic, so maybe you guys could go into a little more detail if you are familiar, but what's the cutoff income for a public defender, or what are the requirements someone would need to meet to get one?
I actually don't know off the top of my head. I think it's something like 150% of the poverty guidelines. It's definitely based on the federal poverty guidelines. And it's going to vary depending on, how many people live in the household and that type of thing. I would say bottom line though, if you think you want a public defender, there is no harm in applying. So, I would say if you're even considering thinking about it at all, if you're thinking, man, hiring a private attorney is something that is going to be a financial hardship for me of any kind, I would say apply.
Or if you have financial resources now that get you denied, but things change, I assume you could reapply in the future if all of a sudden you were unemployed and out of money and still didn't have an attorney.
Yes, you can.
Awesome. Thank you.
Hey, Maddie, could I butt in here quick? I see a lot of people asking about how, I think Josh, you had mentioned requesting discovery pre-arraignment. I think in general, people understand that they can ask for it at arraignment, but if they wanted to ask for it before arraignment, what would be the process for doing that?
So what we've talked about doing, and what I think we will do, is make available forms that essentially you're just going to need to sign and date and mail to the city attorney's office. And I think we can make those available. And Maddie, correct me if I'm overstepping something here. But I think from the perspective of Bruce and Garrett and I, it's pretty easy to get those templates. Can we make them available by email to folks? And then in addition to that, we're working out the details, but we're going to try to figure out a place where you could pick up paper copies if you're not able to access them by email and you're not able to print them on your own. So some of those details we're still working out, but we're going to make that happen one way or the other. And then, bottom line being, all you really need to do then is sign it and mail it to the city attorney's office.
And if you don't ever end up finding that form or running into any of us again, Google Minneapolis City Attorney, send them a letter with your name and court file number on it. Your court file number is 27CR20-something, and say, "Dear City Attorney, I want my discovery."
Yep.
So the next question that I want to address, and probably the last one that's kind of on the same note, is there a head attorney or a legal team strategy? Can we make a mass request to dismiss ASAP? Or maybe have a motion drafted for everyone to submit? So I think that Bruce and Josh, you guys can jump in. I think yes, there is a legal team strategy. There's about 10 or so movement attorneys that have been strategizing around these arrests since they happened. And that's looked like these informational sessions that we've been doing. It's looked like creating that survey that you've all filled out to track cases and screen people for urgent issues. We are still doing callbacks for people who have issues, and we'll be doing more sessions to try to sort out who has really urgent issues and make sure that they're being prioritized for volunteer attorneys as we can. And then I think the question about the motions, I think we still need to sort out the details on how we want to do that. I think the next session that we do for pro se folks will probably be a little bit more in detail on how to fill out those motions if you feel like you need help or if you have additional questions, but we can also like share some of them via email if that's something that folks are interested in. So I don't know, Bruce and Joss, if you have anything to add to that.
No, I would just say I'm scanning the questions now, and there's a lot of great ones being asked that I think show a lot of, good insight. But in general, there's going to be plenty of time to figure this out in terms of, what legal issues are, what questions for cross-examination, how do we push for dismissal. We're not looking at even arraignments or initial trial dates probably until February, March of next year at the earliest. So that doesn't mean we're just going to delay trying to get you answers, but if you didn't get your question answered, keep asking it. We'll get it answered eventually.
Yeah, absolutely. Go ahead, Josh.
Just one, again, scanning the questions, and just one that was related to the public defender question that I was asking before, is asking about whether public defenders are a limited resource and would taking someone's spot, sort of asking, should I forego a public defender even if I might qualify, because I might be denying someone else a public defender? And the answer to that is, well, I mean, sort of, there are a limited number of public defenders, but the public defender system and the court system in general is responsible for providing attorneys for everybody who qualifies for someone. So I think you're not denying somebody a public defender by having one, first of all, bottom line. And second of all, I think that actually sort of goes to the kind of pressure that that the sort of the mass defense strategy is designed to put on the system as a whole. So if the burden is coming from the public defender's office and the public defender has to come to the court and say, we can't take all of these cases, then that might be one more pressure point that helps get to better outcomes.
A lot of questions about social media. Short answer is yes. Anything in your publicly available social media streams can be used against you. If they have the investigative time to look it up and find it, it will be used against you. If it's a private message, private site, then they would need a subpoena or court order to get it from the company. Don't destroy evidence, but you can switch public things to private.
Awesome. So just keeping time in mind, we're at 6:03. Josh and Bruce, do you have any last thoughts or points you want to make before we wrap things up?
No, just that I think there's a bunch of questions that we didn't get to. And we will work on making sure we get answers to those questions, whether they get pinned as topics for the next seminar or Maddie, if there's some that we might, if we look at them and think, hey, this one is time sensitive, maybe we can just do some email responses to some of them too. I'd be happy to help with that.
Absolutely. Yeah, we'll save the questions that you guys asked and we'll start working on those. It could be like a fact sheet that we put on social media, or we could send it out via email or work on them for the next meeting. And then I think we'll also be discussing what the best strategy is for starting to file these motions. And we might send something out to the email list with some instructions, or we might give you more information about what our next session will entail as far as filing those motions, so you guys can get started on all of that. But yeah, just to reiterate what Josh was saying, I know that there's still a lot of questions, but hopefully you all got some answers and got oriented to what this process is going to be like, and just continue to keep coming to these meetings. And we are going to do the best we can to work together to support you all through this process. You have a lot of folks from the Legal Rights Center, from the National Lawyers Guild, from MUAS, and other groups of folks that are all supporting and organizing around your charges as well. So you're definitely not in this alone, even if you are representing yourself pro se. And yeah, we're going to work to keep supporting you throughout this process. So thank you so much for being out there and for everything you do and for fighting your charges. It's really important. And I think with that, we can go ahead and close out for the night. Treya, if you can save the chat and the Q&A, that would be super helpful. Thank you so much, Josh and Bruce, for your time tonight.
Thanks for having us.
Well, and let us know what we can do to answer the questions that didn't get specifically addressed.
We definitely will. Thanks, guys.
you. Thanks, everyone.
Bye.
Bye.
Oh, I see a question from Allie in there real quick. We haven't set a specific date for the next workshop, so keep an eye out on our Facebook. But it'll be in the middle of January. We're gonna do a little holiday hiatus, I think. So.
All right. Bye, everyone. Have a great night.
Bye. Take care.